All right, Talita, I think let's go ahead and get started. I think it's only fair to those who entered at 10 a.m. But good morning, everyone. Thank you for joining us this wonderful and beautiful Thursday morning. Today, we're talking about the Corporate Transparency Act. This is a webinar I've been planning for a while now. I think it's an exciting topic. You don't hear that much about it in the news. It's relatively low key, but I don't think many people understand what I would consider a watershed moment in entity and corporate transparency. This is it's really the first of its type of legislation that's so incredibly broad and that's going to affect so many people, not just wealthy, not just people with shares in large corporations, which ironically I actually exempt, and I'll get more into that in a moment, but small business owners, people with just regular everyday people, whether they be domestic or foreign, are going to be affected by this law. And there can be some harsh penalties for failure to comply. So without any further out, let's get into it. So first of all, my name is, just to give you guys a little bit of background about ourselves. My name is Chris Curtis, Senior Counsel at Trust and Estates. I'm here today with my colleague, Talita. She's also Senior Counsel of Trust and Estates. We handle trust and estates matters for both domestic as well as international clients. And what we mean by international clients are those typically non-resident aliens that are looking to either move to the United States or to make investments in the United States. We also deal with certain tax matters, especially those regarding trust and estates matters. Our contact information is here. Feel free to email or call us if you have any questions after the presentation, or would be happy to answer them for you. So, as I mentioned, the Corporate Transparency Act has arrived. As I mentioned, this is essentially a watershed moment in transparency. We've seen over the years so far, probably the last 15 to 20 years or so, there's been this greater movement to transparency. In order principally to avoid not only money laundering, but tax evasion, right? There's always been a huge amount of criticism in the use of what we call shell companies, which tend to obscure and the identity of people that control it or behind it. And so gradually, not only in the United States, but also in the international community, and I'll go into it in a little more detail, have been putting laws and treaties in place in order to try to combat the tax evasion, money laundering, and so forth. The reason why this is such a watershed moment in the United States is because the United States has never had any sort of, believe it or not, has never actually had any sort of established beneficial ownership of any entities, not only corporate, but any other entities that are created inside the United States. And that's pretty unique to the US system. When you create an entity, you don't actually have to let any state know. It's usually created at the state level. You don't have to let the state know who actually owns the entity. You only usually have to give an organizer name that could be typically a third party that has no beneficial ownership. And the rest is just by private documents. Most other jurisdictions in the world tend to use some sort of government registration system, either on a state level, or at least a central government system, that national government system that tends to keep track of shareholders, partners, members, what have you. Not the United States, at least not until now. So this is the first time this has actually happened. and it is going to affect literally tens of millions of businesses. So before we get into sort of the details of the Corporate Transparency Act, I didn't want to make this terribly, if I just went straight into it, it would be a very dry presentation. I'll probably put a lot of you to sleep. So I did want to actually give a sort of an explanation of where this comes from, right? Because obviously this law comes out of somewhere. In this particular case, U.S. Congress didn't just come out of this and decide to make everyone's life much more difficult. As with most laws, there's usually some reasoning behind it. And this law has actually been something that has been that's been a project for almost decades now. And whereas money laundering, tax evasion has been, it's timeless, right? Since the beginning, since taxes were first levied, people have tried to avoid them. But I would say in this particular case, we could probably go back to 2007. And what is it that happened in 2007? And most of you probably aren't very familiar with it. And that was the issue of tax evasion and lack of transparency. So there was this big case in 2007 that really came to light, and it involved UBS. I believe UBS is the largest bank in Switzerland. I might be wrong, but UBS basically was shocker. Maintaining accounts, secret accounts in Switzerland for U.S. Persons, right? And those U.S. persons were not declaring those accounts, and they were evading income taxes on any gains or any income going into those accounts. Not a big surprise. Everyone knows about secret Swiss bank accounts, tale as old as time, right? But what really made this a bit of a shocker was that what came out of that scandal was that, typically Americans tend to go to Switzerland, meet a banker there, open up a Swiss bank account, and so forth. What was happening with Switzerland was actually actively marketing to clients, to U.S. citizens, U.S. persons, U.S. taxpayers in the United States. And they were doing it in a very unofficial way. They put together a memo that tried to basically a cover your ass memo for the bank, that if they got caught, they were going to point the finger to individual employees and try to put the blame on them, saying it was just some bad apples, some rogue employees. And so one of the bankers involved, his name was Bradley Birkenfeld, found out this memo and realized, whoa, hang on a second, I could potentially be thrown under the bus here by my employer. And so he blew the whistle on them. He actually used a whistleblower law that was established by Congress in 2006 to blow the whistle on UBS. This was in 2007. He basically came out, made it public, what was going on at the bank, and it basically created an enormous scandal. The head of UBS Global Wealth Management, the US was criminally indicted. UBS had to pay a $780 million, almost $1 billion fine, and enter into a deferred prosecution agreement with the US Department of Justice. Now, if you are keeping track of the timeline here, 2007 was right before the 2008 financial crisis. So combined with the 2008 financial crisis, it basically created a huge, huge outrage, both in the public and also in political circles, right? There was a sort of bipartisan outrage at, everyone was suffering economically, and there were very wealthy people hiding their money and doing better than ever and not paying their fair share of taxes. So what came out of all this outrage? Well, basically what we got out of it was, and you might have heard it, you might be familiar with it, especially if you have international clients or you're a banker working at a bank, is a legislation called FATCA. So that stands for Foreign Account Tax Compliance Act, which was passed in 2010. And this was another, I would call, watershed moment in sort of the foreign account compliance with US taxpayers, because this has always been an issue, right? This has always been an issue with the US government. They've always been trying to find a way of how to avoid this type of tax evasion with US citizens going to Switzerland. But obviously the biggest problem was you go to Switzerland, you open up a bank account. Switzerland has its own sovereignty, its own national laws, that very strict banking secrecy, which would make it even illegal for the banks to let the US government know who is, if there are US citizens holding accounts. And so the US government did something very unique, which I actually thought was very interesting. What they did was, okay, well, they realized, well, the US economy is the most powerful economy in the world. That's where a lot of wealth comes from. Everyone in the entire planet, including banks in Switzerland, they invest in the US economy and receive income and distributions, dividends, capital gains from investments in US investments. So what did the FATCA say? FATCA was basically, okay, well, if you're not going to give us that information about US persons, that's fine, but we're just going to deduct 30% of any payments that goes to these countries, because we're just going to assume those payments are going to US persons. And then if you end up actually letting us know that there are actually no US persons and sign off on our forms under penalties of perjury, we'll avoid those withholdings. That actually finally started to make some leeway in terms of how these countries start to deal with, at the very least, American tax evaders. So this essentially led, following FATCA's implementation, not only to a whole series of new documents coming out, W-8 forms, compliance, revamps in compliance at banks, but it also led to certain tax treaties called intergovernmental tax treaties, or what we call IGAs, between the United States and virtually every major country on the entire planet, where each of those countries signed an agreement, including Switzerland, saying that they were going to report US account holders. They were going to keep an eye out for US account holders opening accounts. They were going to make a registration of this, and they were going to send that information to the IRS every year on an automatic basis, what we call the automatic exchange of information. So very, very much a key moment here in terms of fiscal transparency. So here. So what happens after that? Well, basically the world strikes back, and the world said, okay, well, America, if you're putting together FATCA, and remember, FATCA only really is looking for American tax evaders, right? The world's like, okay, well, if America, if we have to send you all this information, and you're really clamping down on tax evasion, and we think we're going to do the same thing. And so the world strikes back, and they initiated a convention called the Common Reporting Standards, initially developed by the OECD. And the Common Reporting Standards is just a response to FATCA, and the international community decided, you know what, let's make an even more transparent system, because FATCA wasn't terribly transparent, at least at the side of the United States. Countries that had to report US taxpayers had to be extremely transparent, go past entities, go look through entities, but it wasn't reciprocal, right? FATCA, if you open up an account here in the United States, for instance, the United States didn't have to report as much information. So basically the international community came out and said, okay, we're going to create our own system. We're going to make it a very transparent system where everyone has to report everything, and everyone behind every sort of entity. It's going to be way more rigorous than FATCA. And it's also going to require automatic annual reporting and exchange of account holders information, right? I think the hope was that if enough countries came aboard, and they do, it's practically the whole world that is a signatory of the CRS, that if all came aboard, the US should into joining this CRS, this Common Reporting Standard system. To date, the US has not joined it and has no plans on joining it. The US is not a signatory, and the US saying, you know, we're actually pretty fine with our own system here, with FATCA, so we don't need to make any changes. So the US is pretty much the only major country that has not signed on to CRS. Of course, because the US, it's very kind of one-sided, FATCA and all these IGA treaties, very one-sided to the United States. The United States doesn't have to give as much information. Everyone started to call the US essentially the new Switzerland. If you want to hide your money, and assuming you're not a US person, park your money here in the United States. We're way less transparent than any of these CRS jurisdictions. One of the CRS jurisdictions, by the way, includes Switzerland. So, so yeah, there was very heavy criticism and pressure from the international community, right, for the U.S. failure to join the CRS system. Critics started to claim that you know, basically the lack of transparency here in the United States was essentially encouraging illicit funds for, you know, tax evasion, corrupt politicians to be sending all their money to the United States and essentially parking it here, be it either in bank accounts with shell companies or shell companies owning U.S. real estate, and of course, the U.S. doesn't terribly mind this because it's just more capital coming into the United States. It was essentially a net positive for the U.S. economy, but obviously there's a moral component here, right? There's only a certain limit that we can look at this and say, well, hang on a second, should we really be receiving all this money from these shady sources outside of the United States? Now, one of the issues in the United States that is a little unique to the federal system of the U.S. system is that the vast majority of entities that are created, and when we're talking about entities, I just mean LLCs, I mean corporations, limited partnerships, limited liability partnerships, those are all created at the state level. There's relatively very few entities that you create at the federal level, and those almost are certainly for banks and so forth. So anyone that's creating an entity is creating at the state level. New York, Delaware, Florida, Nevada, that's where you file an initial registration. Now, to date, when you file that initial registration, if you may or may not be familiar, but typically you have what's called an organizer. You have an organizer that, and I'm an organizer. I actually file LLCs and establish corporations for my clients on a routine basis, and I sign off on the organizational documents. And you file it with the Secretary of State of the Department of State of the relevant state, and that's it. It's formed. And sometimes, I mean, for certain states like Florida, you have to notify them who the director or who the manager is. But for most states, you don't even have to say who that person is. They only need to know the name of the organization, they need to know the name of the registered agent, the name of the company, obviously, how many shares it's going to be issuing, and that's it. Crucially, what's missing from here is what? Is a report of who's the shareholder is, who the member is, who the partner is. You don't need to know any of that. The states don't require any of that. Actually, there really is no system, even if you wanted to report that to the states, there's no system for them to keep tabs on that. So, so this has always been a big hole in the system of the United States. One of the biggest areas of criticism was Delaware LLCs. Delaware LLCs, I got an example here that I'll go through it, just very basic example. Delaware LLCs, for instance, are incredibly easy to create. Actually, New York LLCs, I think, are easier to create. I'm biased, I'm a New York attorney. But Delaware LLCs are very easy to create, takes about maybe a couple of days at most, relatively cheap. Tax-free in the sense that if you're not doing business in Delaware, generally speaking, you don't pay a state income tax there. You just pay a nominal, what we call franchise tax fee to maintain in good standing every year. Delaware doesn't require, Delaware is a very simple form. It's a one-page document. It's called a certificate of formation for an LLC. All you have to do is just put the name of the registered agent. That is it. You file it with the Delaware Department of State. And you only have to start reporting the officers or directors of a company the year following it in an annual report. And of course, the officers or directors of a company don't have to be the actual beneficial owners. They can either be nominees, they could be professionals. That usually the officers and directors listed are not are not the actual shareholders or the beneficial owners of the company. So what did this happen? Well, Delaware LLCs, what happened was bad actors, essentially, let's call them bad actors, started creating Delaware LLCs, and they would hide behind them. And what they would do is, if they had money, say for instance, that from some sort of illicit gain, they would purchase U.S. real estate. U.S. real estate is a great commodity. People like to park money in U.S. real estate, stable, especially in places like New York, just increases in value. They would tend to keep these apartments empty. They'll not rent them out. And so, and this was a perfect way in which to basically hide this money. Why? At least historically, they would, for instance, at least here in New York City, they would create a Delaware LLC. Obviously, no requirement to report the name of the owner of the LLC. The Delaware LLC is then used to purchase valuable real estate in New York City. No name appears on the deed. The only name that appears on the deed is the LLC. And so long as the LLC had no rental income, the apartment isn't sold, historically, there was no requirement to file any information returns to the IRS. The IRS wasn't getting any information from this, and neither was the state government. So this left a huge hole of compliance, a lack of compliance, a lack of transparency of who actually owned these LLCs. Since then, this is a very this is typical, but very this is very typical, and up until probably, I would say, at least here in New York City, up until about 7 years ago, there have been efforts, very limited efforts, to curb this practice. For instance, New York City now requires, since I believe 2015, requires the registrar for New York City requires the owner of the LLC to be reported, at least in the ACRIS document. It's not public information, but they want to know who's behind the LLC. FinCEN started doing what we call geographic targeting orders. If you were purchasing essentially with cash, you had to give the beneficial ownership background information for valuable real estate. But these were essentially were band-aids on a very, very big and much larger problem, right? They weren't essentially targeting and getting all the information. So then what happens, and as a result of this, not only the pressure of the international community on the United States, for instance, the use of these Delaware LLCs, either to purchase real estate. Delaware LLCs were also used to engage in business outside of the United States. And so long as there was no trade or business in the United States, the same way, you didn't have to do any tax filings to the United States. There was just so much criticism going on. Various administrations, especially the Obama administration, tried some half measures. They couldn't get approval for Congress, so they tried to pass some certain limited rules, but they were never very effective. And then suddenly Congress comes and passes what we call the Corporate Transparency Act. This was actually passed in January 2021. It's actually not new. It's almost 2 years old. It was actually vetoed by President Trump right in his last days of his presidency. But surprisingly enough, a bipartisan Congress voted to override that veto. You need 2/3 of Congress. So this just shows how important this is to both sides of the aisle here. This is not a partisan issue. And basically, what does the Corporate Transparency Act require? It requires that all U.S. entities, all entities registered in the United States, and certain foreign entities, and I'll explain what those are later, would be considered reporting entities or reportable entities. And they need to be registered. They need to report the beneficial ownership to the federal government, essentially to FinCEN, who would then keep track of who the beneficial owner is. The CTA required FinCEN to establish rules for reporting, which FinCEN actually did. They issued their final rules implementing the reporting requirements on September 29th, 2022. So it's very, very recent that the final rules came out. So once we got these final rules, we started looking at them and analyzing them and saying, okay, well, now we have some flesh here of exactly what needs to be reported, who needs to be reporting, and so forth. And so yeah, it's going ahead, and it's a very interesting time to be living, because this is essentially the first central registry of beneficial ownership that the United States has ever created. We've never seen this before. We've never seen it at the state level. We've never seen it at the federal level. So this is a huge sea change in terms of reporting information as to these entities. So let's get into it. Let's try to get into a bit of this dry stuff here. So what is considered a reporting entity, at least for the Corporate Transparency Act? Domestic entities. Basically everything. Basically any domestic entity that's, and the key here is any entity formed of some form of filing or registration at the state level or the federal level will be required to report. And my apologies here, this is actually a typo. It says to report annually, but we're required to report at the formation of the entity, actually. And this includes LLCs, includes corporations, limited partnerships, limited liability partnerships. Then you also have LLPs. Then you have, you know, some things I haven't put in here, like professional corporations. Basically, anything, any entity that requires a filing with a state government or some form of government entity here in the United States is going to be subject to these reporting requirements of who the beneficial owners, underlying beneficial owners are. There are some very few exceptions, which I'll get into, but it's basically any domestic entity. Now, foreign entities, not only domestic entities, but also foreign entities as well. And this is one of those rare occasions where we typically do webinars, and our webinars are typically targeted either at domestic clients or international clients. This is one of these rare webinars where essentially this applies to both domestic and international clients. Both US taxpayers and non-US taxpayers. The reason being is because this also, there is certain information that's going to be required of foreign entities as well, more on a limited basis, obviously. Basically, any foreign entity that's registered to do business in the US, or actually de facto doing business in the United States, what we call engaged in a US trade or business, for instance, renting an apartment, is going to be subject to these same reporting requirements, right? And foreign entities, when it says, what does it mean by registered to do business in the US? Typically, let's say, for instance, you have either a foreign company, and when I say foreign company, it could be outside of the US, it could be outside, but that wants to do business in New York State. And but it was registered in Delaware, it was registered in the British Virgin Islands. Those companies, when they want to do trade or business in, for instance, New York State, they have to file a registration with the state of New York, right? So let's say, for instance, you have a British Virgin Islands company that owns a New York City apartment, and they're renting it out. They want to rent it out. Well, that's considered a trade or business. It's a very gray area, actually, New York, and what's considered a trade or business. Renting out property within New York State is without a doubt considered a trade or business. And in order to engage in that trade or business, they need to register as a foreign company to do trade or business here in the United States, in the state of New York. That will then trigger their requirement to actually report to FinCEN, the beneficial ownership of that underlying foreign entity. Sorry, let me get into the next slide. So what is not considered a reportable entity, right? The top one on that list, obviously, foreign entities not engaging in a trade or business in the US, or that hasn't been registered to do a trade or business in one of the states. Those, at least from my point of view, the vast majority of these companies are going to be, they're usually companies, for instance, offshore companies like British Virgin Islands, Bahamas, Nevis, so forth, Panamanian corporations that establish brokerage accounts here by foreign non-resident aliens. They hold passive investments in that brokerage account, passive investments. So those are not subject to reporting because they're not doing a trade or business here in the United States. You're not required to actually register to do a trade or business for those type of assets. The second one is a very limited category of companies. It's what we call unregistered organizations. Unregistered organizations are basically, for instance, sole proprietorships and general partnerships. These are almost non-existent these days, right? These are kind of throwbacks to 100 years ago before we really established more robust corporate statutes, LLCs, LPs, LLPs, and so forth. Back then, it was a lot more difficult to create a corporation. It was a lot more expensive. So what did people do? If they established a partnership for profit, there were certain default rules under the law, but you didn't actually have to register your partnership. Of course, the problem with that was that each partner had unlimited liability. It wasn't a very effective way to govern, and so you don't see too many general partnerships these days. I think I've seen maybe two that are still in existence. If I'm actually a lawyer, I would be subject to malpractice if I recommended a general partnership to a client because of the unlimited liability. And sole proprietorships. What are sole proprietorships? It's basically someone doing business in their own name. And again, unlimited liability. If I, Christian Curtis, decided I wanted to leave my current firm and then just establish my own practice under my own name without an LLC, that's a sole proprietorship, Christian D. Curtis, Esquire. That's basically it. And the reason why these are exempt are fairly obvious. Everyone knows who's behind it, right? There's no sort of there's no entity I'm hiding behind. Everyone knows who's running the show. The third one is trusts, and this is key for obviously for estate planning. The reason why obviously is for trusts. Trusts are private documents. Trusts are not entities that need to be registered with a state government, with a state or federal government. So trusts are exempt. Trust and a big caveat here: trusts standing alone, for instance, a trust directly owning real estate, a trust directly owning assets, are exempt from that reporting because it's not actually an entity in of itself that has to be registered at the state level. Then number 4, there are certain regulated entities, and they always throw this in. The reason being is because they're already regulated, they're already reporting this information. It would just cause more and more paperwork for these systems. But basically, you know, banks, government entities, insurance companies, entities with publicly traded securities, public utilities, and so forth. They're already heavily regulated. So the US government isn't terribly concerned about them. And then the last one, the last exemption, is for large operating companies. These are ones that have offices in the US, has a minimum of 20 employees, and has at least $5 million in gross receipts per year. Obviously, they don't want to create additional reporting burdens on these very large established companies where it's highly unlikely that people are going to be using them to launder money. Not that it can happen, but they just perceived it as a lower risk. And considering the fact that this is already going to capture literally tens of millions of companies, it's somewhat understandable why they're trying to put these limitations in, I think reasonable limitations into place. So the question now is, what will actually need to be reported? And this is where reporting essentially is essentially going up to that level of that CRS, that common reporting standard, where there's a greater amount of transparency. Because typically when you report a beneficial ownership, at least for foreign persons, the previous rules, these Band-Aid rules, there were bigger holes than Swiss cheese in these rules, to be honest with you. You could easily get around them just by making some tweaks to the entity itself, by creating an irrevocable trust, by putting a professional trustee, and that would usually solve the problem for the person that didn't want to be essentially outed as a beneficial owner. So this information that's being reported is looking to target who actually is in control. Who is in control here? And the following information that must be reported for FinCEN regarding a reporting entity and all beneficial owners. What will be reported is, at least for the company, for the entity itself, obviously the company name, if it has a trade name or doing business as name, obviously its address, its state of formation, and crucially an EIN number. And this cannot be overlooked for foreign entities, because foreign entities or even domestic entities that are owned by foreign persons, EINs can take a while to obtain. They're usually pretty fast about issuing them, but we have had some issues. We actually have had some issues. Me and Talita, for instance, we just had an LLC which had an unprecedented time of getting an EIN, lots of phone calls to the IRS, lots of frustrating backs and forth. It literally took us 5 months to get that EIN. You're going to need an EIN for these entities to report. And so if a company doesn't have an EIN, I would recommend obtaining it. EINs actually, by the way, do not create any sort of tax burden where there wasn't one in the first place. Any entity can obtain one. There's no requirement for it to actually have employees. It's called an employer identification number, but there's no requirement to have employees. There's no requirement to be doing a trade or business in the United States. It's just good to have, just because you're going to be ready in order to comply with these reporting standards. You certainly don't want to wait until the last minute to obtain an EIN. If you don't obtain it, then you could be subject to the penalties that I'll discuss later on. Next of all, who is actually considered a beneficial owner of an entity? Right. This is essentially a very, very key question. Who is actually going to have to be reported behind these entities? Beneficial owner is basically defined on number 1 and 2 here. The rule defines them as anyone that owns or controls 25% or more of the reporting entity, or 2, exercises substantial control over the reporting entity. Right. So the second part here, someone that exercises substantial control over the reporting entity, is essentially a catch-all. It's essentially, look, because they see owns or controls at least 25% more of the reporting entity, well, you can gain that. You can easily gain that. You could get a bunch of family members that each have, that are in cahoots with each other. There's a patriarch, doesn't want to give his name, so he gets 4 of his kids, or gives himself a small participation. But at the end of the day, that patriarch is the one that's calling the shots. So what they want to do is there's like, okay, well, you may have less than 25%, but if you're really exercising substantial control over the reporting entity itself, if you're the one really de facto calling the shots, then you have to be, your information actually has to be reported. Crucially here too is, number 3 here is, for any entity created after January 1st, 2024, a company applicant must be reported. And this is the person who files or registers the entity. And that's regardless of whether or not that person actually is a beneficial owner of the entity. And so this is also going to affect professionals. This is going to affect mainly legal professionals such as myself. From 2024 onwards, if I create an LLC, for instance, as an organizer, I am actually going to have to be listed, not as a beneficial owner, but what we call a company applicant. I was the one that actually formed the company, and my name is going to have to go down there. If Talita creates it, Talita's name has to go down there together with the actual beneficial owners. So that's key as well. If you don't put that information in, then you're essentially in non-compliance and can be subject to penalties. So that's something to consider, not only for myself as legal professionals, but for instance, accountants too. Accountants also tend to create these entities. They have to be on top of this. Now, crucially, what are not considered beneficial owners? First one's a minor child. Minor child is not considered a beneficial owner, but on the caveat that the legal guardian or the parent, or at least one of the parents, is actually reported, right? So if neither legal guardian or parent is reported, then the minor child actually does have to be reported. Second, an individual acting as a nominee, intermediary, custodian, or agent on behalf of another individual, for instance, attorney in fact. You also have very common in the international sector, you have what's called nominee directors, nominee shareholders, people that are essentially acting on behalf. You don't have to report those names. If I, for instance, just give you an example, if I, for instance, had a client that came to me and said, hey, I want you to be my nominee, which is essentially a straw man. I want you to be my nominee because I don't want my name to go on the share certificate. So the share certificate is Christian D. Curtis, but then I have an agreement, a nominee agreement that says I don't actually own this share certificate. I own it on your behalf. I own it for Mr. Client on Mr. Client's behalf. And Mr. Client is really the one that calls the shots. It's his money. So I don't have to put my own name as the nominee of Mr. Client, but Mr. Client's name does have to be listed, because even though he technically doesn't own or control 25% or more of the reporting entity, he has substantial control over the reporting entity, because obviously I'm not doing anything without Mr. Client's consent, right? So the third is a non-owner employee of the company, right? You don't actually have to put, if it's got several employees, you actually have to list all the names of the employees, except high-level executives and officers, people that are calling big shots, even if they're not a shareholder or a member. they should still be listed as well. I would typically say officers, for instance, or managers of an LLC, or the directors or VPs or presidents and so forth of a corporation. Number 4 is an individual whose only interest in the entity is a right of inheritance. Now, this is key from an estate planning perspective, because obviously you would have, let's say, for instance, you have a trust that, and typically we have a lot of LLCs that are owned by trusts, and they're typically revocable trusts. The client puts themselves as the initial trustee, and then as the initial beneficiary, and then perhaps a spouse or kids in the event of a death become the beneficiaries. In those situations, the beneficiaries, because it's also a revocable trust, the beneficiaries only have a mere expectation of an inheritance, right? They only have a mere expectation of a distribution in the future. They don't essentially have any sort of established rights at this point. So they could either be removed, they could pass away before they actually get into that role of the beneficiary, so they don't have to be reported. So this is actually a really key thing, because it kind of relieves the burden of myself, accountants, and so forth, of having to take a trust instrument and like, oh my God, am I going to have to list the great grandchildren here that might already be living, but they're probably not going to inherit until 10 other people pass away. Now, the key thing here, which probably all of you want to know, is when does reporting actually begin, right? We've gone through all this information. Everyone's probably, oh my God, there's going to be penalties here. When does this begin? Did it begin yesterday? Is it going to begin January 1st? The good news here, we have a couple of years, all right? We have a couple of years of lead time here to get used to this and to begin reporting. So we still have a couple of years here. For entities that are formed prior to January 1st, 2024, such entities shall be required to report no later than January 1st, 2025. So any entities that exist today, they have until January 1st, 2025 to begin reporting the beneficial ownership information. So there's plenty of time here. We still got at least 2 years. For entities that are formed after January 1st, 2024, however, reporting must be completed within 30 days of the entity's formation. So once the entity is formed, people like myself that are helping out, I'm going to have to send a report, obviously with the client's consent and acknowledgement, that here are the list of the beneficial owners of the entity, and send that to FinCEN. And essentially all entities will be required to report beginning January 1st, 2025. And by the way, also any changes in beneficial ownership must be reported within 30 days of such change, or when you become aware of such change. If you're a third party, those must be reported as well. So it's not just, report it, then change the beneficial ownership after you report it. No, that also has to be reported as well. And what are the penalties for failure to file? Because obviously without penalties, who's going to bother even reporting, right? There's always penalties here, especially for anything that has to be reported to FinCEN or the IRS. Civil penalty, up to $500 per day for each day the violation continues or has not been remedied. So obviously that can become very substantial with each passing day. And that's civil penalty, right? So that's essentially what we tend to call in the law strict liability. If it wasn't done, then you're guilty. Then obviously you have criminal penalties. Criminal penalties is when the government can essentially establish typically the difference between civil penalties and criminal penalties. From a legal perspective, is criminal penalties usually need some form of intent that the government has to prove in order to prosecute beyond a reasonable doubt. Civil penalties are just they just have to prove that you actually didn't file it. Criminal penalties up to $10,000 fine, or prison sentences up to 2 years of both. Having said that, don't worry terribly about criminal penalties. They always throw it in there. It's usually pretty rare. I've seen for criminal penalties to be for the IRS or FinCEN or federal government, US DOJ, to actually go after to assert criminal penalties. They only typically do it in very egregious cases. 2 reasons mainly: it's more difficult to prove. Second, prosecution is very expensive. They have to throw a lot of resources at it. So typically you're not going to go after criminal penalties if, a mom and pop forgets to file and so forth, right? They want to go after the big fish here that have an intent to obscure who the true beneficial owners are. And key information here: who will have access to reported data, right? Now, the difference here with the US government compared to many governments outside of the United States is the information is not going to be available to the public. It's going to essentially be confidential. The only people that are going to have access to it: one, US federal government, obviously; two, US federal law enforcement; three, US banks are going to have access to it; four, state and local law enforcement, right? But that's only if a court order is obtained. So there's even a limit to the state and local level of law enforcement. There's going to be no public access, right? You can't just go on Google. You can't just go on some public database. So that's good, because that essentially keeps this information private. And six, information, crucially here, information shall not be subject to automatic exchange under the IGA agreement. So the US, it's sort of, I guess if you're looking at it from an international perspective, it's probably still a half measure. I mean, the US government's really going to be the one keeping tabs on this. And so it's probably still frustrating from an international perspective. If I, for instance, am, French government, and I feel like I have French citizens that are hiding money in the United States, I'm not going to automatically get this information on the IGA agreement that was signed with the United States. So someone still leaves the United States. It's sort of, I almost see this law and these sort of limitations as the US trying to placate the international community, saying, hey, look, we are doing something. We are now keeping a registry of beneficial owners. So we're not being hypocrites, but you can't have this information. You can only have this information if we say so. So in that respect, the US is still keeping some form of moral obligation to try to avoid tax evasion and money laundering, but they still keep it private enough, I feel like, to keep people, foreign persons outside of the United States, to keep throwing money into the U.S. economy, be it by opening bank accounts, purchasing real estate, and so forth. Because one key element here, if you're unfamiliar with reporting systems outside of the United States, is that there is a tendency for these systems outside of the United States, and it always has been, actually, it's not a tendency where they're moving towards something. It always has been kind of de facto or de jure rule that these countries outside the United States, the vast majority, actually do have public systems of who shareholders are, who members are, who partners are, and they're trying to force countries to create similar systems. The UK, for instance, has UK Companies House. You can go to look up UK companies, and you can search a company, and it'll give you all the individual beneficial owners who have control over the companies, right? The UK is trying to make the British Virgin Islands do that. They're forcing them actually to do that. And the US so far is not going to rise to that level, and not so much in the near future. But having said that, the US government will know who is behind these entities. Of course, the question can be, can you put a straw man in there? Can Vladimir Putin find someone, instead of opening it up, obviously saying, Vlad owns this, instead of then just put, some, unknown person? Yes, potentially, but that unknown person is taking huge risks. They have to sign on the penalties of perjury. If they can't show where they got the income from, then they can be subject to prosecution, to criminal penalties, right? So it's a big risk that they'll be taking. Of course, what's the effect on this on estate plans? I've already touched on this throughout the presentation, but effects on estate plans. Obviously, like I mentioned, trusts by themselves are not subject to reporting, but trust information needs to be reported if the trust is a beneficial owner of a reportable entity, right? The trust owns an LLC, if the trust owns a foreign corporation, the trust owns a domestic corporation, or even indirectly. For instance, we create structures where a trust owns an offshore company that then owns a domestic corporation that owns US real estate that's being rented out. You're actually going to have to report that trust information. Obviously, closely held family businesses, right? Whether they're outside the United States doing business in the United States or a domestic entity, those are going to have to start reporting as well, be subject to those penalties. Family limited partnerships, which are a very common planning tool in order to get what we call discount planning on gifts made to the family limited partnerships. And also something what we call private trust companies. Those are a little bit more rare. We typically don't use those terribly often with clients. Private trust company is more for the very high net worth clients, want to maintain control over a certain period of time. We're a family office that manages the high net worth families' assets. Private trust companies are basically entities that are established to be the trustee or a protector or some form of fiduciary for one single family, right? So it's not uncommon to see private trust companies as trustees of certain trusts. Those would obviously also be subject to reporting. Why? Because they have control, substantial control over the trust, and the trust is essentially a shareholder or a member of an LLC, and so would control the LLC and or the corporation. And that's the end of the presentation. Hopefully that wasn't too long. It wasn't too dry. Obligatory disclaimer here. This isn't legal advice. I'm not your attorney. I can be your attorney or your client's attorney. Feel free to reach out to us. Not everything may be accurate, may change with time and so forth. If you have a question, feel free to contact us. But right now, I will just open it up to questions, see if anyone has any questions right now. If you haven't already got sick of hearing about the Corporate Transparency Act, leave it in the chat. I'll just give it a few seconds here. But if there are no questions, then that will do it for the end of the presentation. Obviously, if you have questions after the presentation, feel free to reach out, email me or email Talita. A few other things too is that while they came out with final rules in September 22nd, the actual forms themselves that are going to have to be filled out, the way it's going to be reported, is it going to be, you're going to have to mail it in, fax it in, do it online. They're still working that out. Those are things they're still working out. And so they haven't come out with those yet. So that remains to be seen, but we do have it more fleshed out now on what is actually going to be reported. And just remember, don't get terribly concerned yet. We have plenty of lead time here. We have at least a year here, so don't rush out to figure out how to do this reporting. It's still gradually being developed. But if you're especially a professional, keep this in mind. It's something to mention to clients as well. It's just to mention to clients, that there is going to be a certain level of reporting. If they have any questions, then they should reach out to a relevant professional. And chat, I have, no, oh, okay. Oh, thank you, Kate. Very much appreciate the kudos there you sent me. So with that said, thank you all so much for joining us this morning. Any new developments, we like to send newsletters out. I'll keep the newsletters coming. Feel free to register newsletters with Lamani Knight, who handles our marketing for the firm, and we'll keep you up to date with any new developments. All right, and for now, that's it for us. Take care. Bye-bye.
Bye.